All right, let's look at chapters 3 and 4. And I know you're worried. You're thinking, oh my goodness, he took forever on the last one. This will be much shorter and hopefully, therefore, much more manageable. Chapter 3 from Gifford is related to negotiation planning. And as I've already said, probably one of the keys to doing a good job and an effective job negotiating is getting your planning straight and knowing kind of where you want to go, why you want to go there, and how you are going to get to where you want to go in the negotiation. This doesn't mean that you'll have every little thing planned out. You can't turn it into a script. This is not a movie. It's a fluid situation. You're going to have to make adjustments on the fly more than likely, but you have to have a basic plan and a basic strategy in place so that you know and understand where you want to go. If you do that, you're putting yourself in a position to be able to adjust more easily when you need to adjust, ironically enough. It's like learning to play the piano or the guitar. At first, you have to really practice hard. You have to strum I guess the chords again and again to learn to play the guitar. You have to learn the keys on the piano. But eventually, after you discipline yourself to really work hard in preparing, eventually you get to the point where you're able to play the piano or the guitar well and have a little more freedom. Same thing with negotiating. You just simply have to prepare, prepare, prepare. The old Boy Scout idea. Just be prepared. All right. How do you do negotiation planning? I mean, it's a practical thing. How do you do it? Uh, First thing is you ask your client, what do you want? At the office I work at right now, there is a guy who does a lot of negotiating, and one of the things he often asks the client is, well, what do you want? What do you want out of this deal? And then he'll tell the client. If the client says, well, I want something outrageous, this fellow will tell the client, that's probably not going to happen. Let me give you an idea of what I expect is more likely to be the outcome based on all of my years of experience and things I know. But that's always a good place to start. What does the client want? Uh, Second, particularly when it comes to negotiations that are involved, let's say, that are detailed, that involve maybe multiple parties, or that involve sophisticated situations, whether it be a corporate buyout or a large leasing arrangement or something like that. You're going to have to lean heavily on your client. You're going to have to get information from the client that's absolutely critical to the success of the negotiation. And so you have to spend a lot of time pre-planning with the client. What do we know? What do we need to know? What questions do we need to ask? What information do you need to make a good decision? As you're gathering the information you need, you'll try to get as much of the information that you can obtain through sources other than the other side, only because you don't want to walk in appearing like you don't know what's happening or you don't know what's going on. So your client can be an invaluable source of information. Don't neglect dealing with your client, talking with your client. That seems elementary, but quite frankly, as lawyers, we often are jacks of all trades, and we sometimes get a little ahead of ourselves in that way. What else? What are the client's interests? I mean, we've got to know what interest the client has in the matter. A criminal defendant has a particular interest, maybe in staying out of jail. Although I will tell you, I did a little criminal defense years and years ago when I was a young lawyer, and had one client. I told him I could get him into this program for drug offenders. He said, no thanks, I'll just do the jail time. And I thought that was a bit peculiar, so I said, well, why? And he was a big man. And when I say big, I mean this guy was enormous, 6'7" or 8" and about 300 pounds. And he wasn't a big, huge, fat, flabby guy. He was just a big, big mountain of a man. And he told me point blank, he said, look, if I go to jail, I got 3 squares, got a roof over my head, and nobody bothers me. And so that was his attitude. He just as soon go do the jail time. He said, I won't be in that long anyway because I always behave myself. He'd been in jail before. He knew what the deal was. And for him, it was better than worrying about trying to do some program and fix himself, I guess. I don't know. So what are the client's interests? It isn't always money, although more often than not, the negotiations we find ourselves involved with do deal with money, but that's not always the case. Don't assume, even if money is the vital part of the negotiation, don't assume that's all your client's interested in. Years ago, I was involved in a negotiation with a client who had suffered significant burns over a large portion of her body. And she was very, very concerned that the other side admit fault. And that was a big deal to her, that they needed to admit that they had done wrong, that the other parties had done wrong, causing her this grievous injury. After a long span of talking and working with her and counseling her, in effect, we finally were able to get her to understand that that's just not how the system works. I mean, people don't, when they settle with you, they don't admit anything. The settlement itself is the only admission you're going to get that they might have done something wrong. She got a very large settlement, quite frankly, and I think she understood when she got the money that did represent an indication that they had done something wrong, given the size of the settlement. But it's not always about money. There are ego issues too here, maybe yours. Be careful about that. We don't want your ego to get in the way of a settlement or a resolution or a relieving of the tension, as I've tried to frame it earlier on. So keep that in mind. You need to ask, when your client takes a position, ask them why. Okay, you've got to be the 5-year-old here. Why? 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 That's not just so that you can look like you care. It's because you need to know these things in order to effectively understand both where your client is coming from and both where the other side, how the other side may react. You're going to have some expertise, particularly as an attorney, and you may have specific expertise with the other side, but you're going to have legal things in mind that you're going to need to deal with, and part of your job is to know why your client wants to do what they want to do, because then that may impact whether you can or can't do it. It's always worthwhile to ask the other side the same question. Why do you want that? If they're asking for a particular concession from you, you're going to have, you need to ask, well, why do you want that? Look, why is one of those open-ended questions that puts people in a bind, because they actually have to talk. They can't. It's difficult to weasel around when somebody asks you why. Why do you want that? Again, they may or may not explain it to you satisfactorily. Even the failure to explain may tell you something about the other side's position. Failure to explain may tell you something about your client's position. If they don't know why they want something, then maybe it's time for you to step up and say to your client, well, if you can't explain why to me, I can't explain why to the other side, and if I can't explain why to the other side, they're not likely to give us that concession. So we need to be able to give them a reason. Questions unasked are questions unanswered. I'll say that again and again. Understand that where you need to understand both with whom you are negotiating and for whom you are negotiating. There is a scene in the movie Braveheart in which, and if you've seen the movie, great, you may remember this, you may not. If you haven't seen the movie, you ought to watch it. It's a good movie. But there's a scene in the movie Braveheart where the main character is negotiating with the Princess of Wales. And the king, Longshanks, has sent her because his son is effeminate, and he's worried that his son will be seen as very weak. He is afraid to go and negotiate with the Scottish upstarts because he's afraid they might kill him, so they send the princess, thinking, well, maybe they'll negotiate with her. The princess suggests to the main character, the Scottish roustabout here, who's fomenting revolution, that perhaps he should accept titles and lands and a box of gold, and he basically tells her, I'm not in it for the box of gold or the lands or the titles. And she says, this is how peace is made. And he said, no, this is how slaves are made. Unfortunately, the king had not spent any time figuring out who his opponent was, and he didn't know his opponent at all, and he knew nothing about him and asked no questions and arrogantly presumed that he could buy him off. And it turns out that this particular Scottish rebel was not going to be bought off because he cared more about freedom than he did about money or lands and title. It's a simple example, but it's a real deal here that you've got to know with whom you're negotiating. Another movie example, I don't recommend this movie nearly as strongly as Braveheart, but another movie example is A Few Good Men. In that movie, Danny, the main character, played by Tom Cruise, is known for his, shall we say, aptitude for getting things resolved out of court. He doesn't go in and try cases, and he is assigned a big murder case because he doesn't try cases. He settles them. And there is a concern that this particular case needs to be resolved outside of court. Along the way, what you see is Danny getting a great offer from the prosecution, and he goes to meet with his clients, 2 Marines who are accused of murder, and tells them, hey, look, I've got this great deal for you. You'll have to go to jail, but you'll be out in 6 months. And one of the Marines looks at him and basically says, but we didn't do it. And Danny says to his clients, it's a hockey season. Come on, take the deal. It's a great deal. What he doesn't understand about these Marines is that when they say God, core, and country, they really mean it. They have a code, and they live by their code, and they don't care about deals. They care about the integrity of what they believe and the integrity of the system. And Danny doesn't even know his own client and doesn't understand that that's how they work, because he hadn't taken time to get to know them. So, all right, how do you evaluate your client's situation? Well, what do you do in order to get to understand your client? First, you got to come to some kind of bottom line, whatever you're going to call it. Fisher and Urey in the Getting to Yes, they call it a BATNA, B-A-T-N-A, best alternative to a negotiated agreement. Gifford talks about this as well. What does this mean? Well, what this means is that you think very clearly, if we cannot resolve this matter through negotiation, what's the next best possible thing that's going to happen to or for or with my client? And again, this is going to require a great deal of discussion with the client and getting to know them and understand what they need. How do you evaluate your client's situation? Well, A, your own experiences, to the extent you have them. Look, I don't care whether you're 25 and you're just finishing law school. You have some life experience on which to draw. If you're older, and I know some of you are, and you've had some background in business or in education or wherever, you've got some life background to draw on it, whatever it is, whether you're 25, 35, or 55. Draw on that background in order to try to understand your client's experience. We all have things in common as human beings that we can all draw on. Second, what's the local custom? I guess I should say B. I think I said A first. So A, draw on your experiences. B, what's the local custom? Is there a local custom? If you don't know the local custom, ask around about whether there is any. And by local custom, I mean for this circumstance, what do people normally do? Again, it's a guide. It's not a default position necessarily, but it's a guide and helps you figure out what would be reasonable for your client? What would be reasonable for your client to expect as far as an outcome? If it's litigation, you're going to have to consider some things. And this is specific to litigation. It does probably bear on non-litigation matters, but litigation in particular, you're going to have to think about A, witness credibility. Is your client reliable? Is your client a good witness? Will your client make a good witness? Will your client hold up under cross-examination? What about your other witnesses? Jurisdiction. What's the nature of the jurisdiction that you're in? Is it a good one, a bad one, good for your case, whatever? What about legal precedent? I mean, what's going on legally in terms of what you're trying to do? Is there any legal precedent that affects you? Then any case-specific factors that might factor into your case. And that can get very specific. So just things that you'll have to think about. Always use common sense and judgment when you're dealing with these things. You're always going to want to think about that. Again, a good horse sense will always be very effective in thinking through things. I would always say whenever you come to a conclusion, as you're preparing for the negotiation, as you're planning for the negotiation, every time you come to a conclusion, ask yourself, just sort of ask yourself, does that seem reasonable? Is where I'm going, does this, try to put it aside and look at it and kind of go, oh, does that seem reasonable? Or is it unreasonable? Is it stupid? Is it crazy? Is it sensible? Whatever. Put it to the test. Brainstorming is a useful tool if you have people with whom you can brainstorm. It's always effective. Even if you don't, you can always do it yourself by simply making a list of proposed actions, proposed strategies, proposed tactics. Just make a long list. And if you're not familiar with brainstorming, it's the concept of just throwing stuff out without analyzing it. You just think up ideas, you throw them out, you put them on a piece of paper, you type them on your computer, whatever, you type them on your phone, wherever you put stuff like that. You come up with a list of things that relate to the issue. So if you're getting ready to negotiate a business deal for someone, your client wants to buy a company for some reason. Let's say your client is another company, so you've got a company buying another company. Okay, what are things we need to think about? Is this going to? I mean, are the companies big enough that it will cause any antitrust issues? Are there any legal regulations that would prevent these two companies from merging? Does it have to be a takeover or does it have to be a merger? Are you going to swap stock? Are you going to pay cash? How are you going to pay for this other company? What are the alternatives to paying cash? What are the alternatives to swapping stock? What about the officers of the company? How are they going to mesh? What are you going to do with the officers of the company that is being bought? Are you buying just the assets or are you buying the actual corporation? And you throw these things out. You just start throwing things out in order to sort of set up the things that need to be negotiated. Maybe there's certain aspects that don't need to be negotiated. Maybe it's clear that it's going to be a corporate takeover. That is a corporate buyout of another corporate. You're going to buy the corporation, not just the assets, but the actual corporation. So maybe you know that going in. But you can throw those things all out and start brainstorming, and then that will impact how you think about negotiating, how you prepare for the negotiation. One of the things that is familiar to negotiators who study this and in the lingo is something called a reservation point. The idea of a reservation point or tripwire or other magic language like that is that you choose a place at which, if that point gets hit, that tripwire gets hit, you know you are at about the end of your ability to negotiate. And that kind of sends up flags and red flares and bombs burst and alarms go off and everybody's going, oh no. So you have to kind of know where that is and maybe set something. It's a bit artificial, but at least it's a way for you to know you're coming to the end. And if you don't get the tension, whatever it is, if you don't get it resolved, you're going to have a problem. You're not going to get the negotiate. There's not going to be a negotiated resolution of whatever it is you're negotiating. How do you pick that? Again, a lot of contact with the client, a lot of discussion, and a lot of figuring about the legal issues that might surround the matter. And taking all those things into account and then coming up with sort of that artificial tripwire or reservation point, or whatever you want to call it, alarm point. You can call it whatever you want. As one old law professor used to tell the students where I went to law school, he said you can call the thing a gumdrop. It is what it is. So call it whatever you want. Call it your gumdrop point. That's gum, G-U-M drop, not gun drop. Just being clear. how do you analyze sources of leverage and power? That is, how do you figure out where you have leverage and where you have power? We kind of touched on this a bit in the introduction, but now we're going to talk about it a little bit more in detail. Probably the number one thing that tells you what kind of leverage you have or power you have is whether you have other possible things, if you will, other possible answers to the tension that's in question. If you are a criminal defendant, what are your options? Let's say that the evidence looks pretty bad for you. If I'm your lawyer, I'm saying, look, here are your options. You plead guilty and we get the best deal we can. You go to trial, you get creamed, and then they kill you. You leave, you flee, but of course then these charges are hanging over your head the rest of your life. And if you get caught, you're in bigger trouble, because then you'll be charged with, fleeing the jurisdiction. That runs into all kinds of problems. And I'm not sure you can ethically tell your client to flee, but you can probably tell your client that's an option. I don't recommend, but that it is an option. Again, what's the best alternative for that particular client? And that's something you'll have to think about. What is it? If you're talking about a personal injury case, let's say you represent a plaintiff who has been injured, and you're talking to the client about what's your best alternative to a negotiated agreement. Well, the answer is litigation, and that's it. Or you admit that you shouldn't get anything, and you just move on with your life. Those are basically your only two alternatives. There's not a lot of wiggle room in that scenario. With a business deal, there may be multiple possibilities. Let's say you are seeking to lease a space from a particular organization, and the city where you are seeking to lease the space has lots of space available, and you're looking at a downtown location, and there's 50 buildings in the downtown area that would suit you. Well, then you've got lots of leverage, even though you're the lessee. Even though it would seem like the lessor would have, the big company with all the space would have the leverage, not necessarily. I mean, you may have 20 different alternatives, places that you can go to. Let's say you say, look, I'm leasing 5,000 square feet in downtown, name your city, that's of any reasonable size. Now, let's just say downtown Norfolk, because it's near Virginia Beach, where the campus of Regent is. Well, if there are 25 different places that have 5,000 square feet of leasable space that would suit your needs reasonably within a 10-mile radius, let's say, well, then you've got an awful lot of best alternatives to a negotiated agreement. So that gives you a lot of leverage. Friction costs on the other side. Regardless of the legal position, there are often costs associated with getting a negotiation resolved, or getting anything resolved, one of which may be the legal fees associated with getting it resolved. And there may be other costs. When I say friction costs, I'm talking about the costs outside of the actual resolution that it takes to get to the resolution, whether those be simply legal fees for the lawyer to negotiate, whether it be regulations that require payment of certain fees upon doing certain activities within a jurisdiction, whether it means litigation fees for litigation in terms of expert witnesses, filing fees, those kinds of things. Those are costs that can lead to leverage. If you know that the other side really can't afford to hire an expert, and it's really going to strain them, that gives you some leverage that you might not otherwise have in the litigation if you know they need an expert in order to prove their case. And so that's something to consider. The lawyer's expertise and reputation, that's obviously a factor when you're doing legal negotiations in particular. That certainly, no doubt, applies in other communities where negotiations happen. I said in the last lecture that people do know and they do talk, so keep that in mind. There was a guy I used to deal with regularly. He got what we referred to as the Bob's bump up. His name was not Bob, but I'm just going to use that. And the reason Bob got his bump up was because we knew that he was a very effective litigator who knew what he was doing and who was better, quite frankly. He was a better lawyer than most of the other lawyers we dealt with. I thought, personally, he was the best trial lawyer I'd ever seen. So he got a little more money from us than other people did. Past relationships between the parties and the negotiators, that also determines leverage. Maybe this is somebody you've negotiated with before, they're a pushover. Or they're not a pushover. They're very difficult to deal with. Those are things that matter and impact what kind of leverage you have or don't have. Time can be a huge matter of leverage. One of the claims examiners I worked with for many years used to wait and wait and wait and wait. He would never settle a case until the last possible minute. But what he had learned over many years, with many years of experience, was that if somebody's going to settle the case, they'll settle it pretty much at any time. And he liked to wait until the pressure had really built, like this pressure cooker thing. The other side was waiting and waiting for a reasonable offer, and then finally he'd make a reasonable offer, like right at the last possible minute. And they almost, in fact, I don't remember the other side ever not taking it. They always took it. And what I learned from him was that gave you leverage. It put pressure on the other side. They got nervous. They got worried. What do they know? Why aren't they responding to our offer? Why aren't they being reasonable? And then suddenly that reasonableness right there at the end let off a lot of steam and got the cases resolved. Time pressures and time limit demands, trial dates, those kinds of things, contract expiration dates, those can be sources of leverage, either for you or against you, obviously, depending. But those can be things you can use to put pressure on the other side, or they can use to put pressure on you. The party's level of commitment, it can be a matter of leverage. This goes back to the example I gave to some extent with the Braveheart movie, where the Scottish rebels weren't going to be, they just simply didn't care about the gold and the titles. This particular rebel, he didn't care. He wasn't going to be pressured by that because it didn't matter to him. His level of commitment was such that he was much more interested in freedom and the idea of having the Scots free from English supremacy. Well, if that's his level of commitment, he's willing to die for it. And I won't, for those of you, if any of you who have not seen the movie Braveheart, I won't tell you what happens, but he was willing to die at any time for his commitment to Scotland. Well, then that says something. Okay, and that tells you something about his level of commitment. Now, Gifford, when you read Gifford, you'll find that he suggests that somebody saying they're going to take something to the Supreme Court can be a source of that commitment. That has to be realistic, though. Okay, that has to be a realistic commitment, because people will say that all the time. I'll take this all the way to the Supreme Court. When they realize how much it's going to cost and the time and energy that it will take, they often change their mind. So that's got to be realistic. There may be power over the other party because of financial or other considerations, and I think I've kind of touched on that, for instance, with the idea that somebody can't afford to hire an expert, that kind of thing. Somebody can't afford to stay in, maybe you've got a tenant who is paying a ridiculous lease and it's strangling their business, and they've got to get out. And so you may learn of that as the lessor of the new spot and know that you can maybe get a little bit better deal because it's still less than the deal they're in, for instance. All right. Initial orientation, which is chapter 4, and this will be even briefer, so we've gone about 30 minutes, and this will probably take another 8 or 10 famous last words, but you won't go an hour this time. The initial phase involves an exchange of proposals, information gathering and disclosure, and then tactics that are used to affect the relationship between the parties. What does this mean? Well, let's talk about competitive tactics, and I'm going to focus mostly on the tactics issue. We've talked about information gathering from time to time throughout already. Questions unasked are questions unanswered. You've got to know your client. You've got to know as much about the other side as you possibly can. You've got to know as much about the deal as you can possibly know. Again, within reason. You're not going to have an unlimited budget no matter what. And so you're always doing things within parameters, but you need to get as much as you can, as much information as you can about the circumstances of this negotiation as you can within the parameters allotted. All right, some of the tactics you might use as you engage in the initial orientation phase, that is the beginning of the negotiation. Agenda control. Is there going to be an agenda? Can you control the agenda? Usually most negotiations don't have a written agenda or even a formal agenda. So that if it does, then great. You may try to control the beginning of the negotiation by controlling how it gets done. That's usually only in fairly complex negotiations. You're not going to have that in an ordinary negotiation in a personal injury case or a criminal defense case where you're going in. Sometimes, by the way, I'll just throw this out. I'm sorry, but it just popped into my head, and I usually mention this little example. You know, oftentimes you think the state has all the leverage in a criminal defense case. So if any of you law students end up doing criminal defense, keep this in mind. Or if you're going to be a prosecutor, keep this in mind. Young prosecutors often walk into small court, the lower level court, with a stack of 100 misdemeanor cases. And as those prosecutors soon learn, particularly if they're married or if they have kids or anything like that, you can't try every single one of those. You just can't. You can't take 100 of those and try them all day. The criminal defense attorneys will all hate you. The judge will hate you. The clerks will hate you. The bailiffs will hate you. And it's not necessary. But here's the interesting thing. As a criminal defense guy, I had leverage because I could walk in sometimes with a criminal prosecutor who had 100 cases and say, look, let's make a deal, and get a decent deal for my client because the prosecutor just couldn't handle all those cases in one day without dealing some of them out. It's just the way it is. So, all right, what about the negotiation site as a competitive tactic? We talked about agenda control. What about the site? I knew this one lawyer. He did everything at his office and thought that it gave him some monumental advantage. And my attitude about that is, I'll go anywhere you want to go. I don't care. It's like home field advantage. Does it really exist? Maybe in sports, but even then, not always, right? Home team doesn't always win. And I think that's the kind of thing that if it affects you, shame on you. Don't let it affect you, okay? Don't let it bother you. What about the physical arrangements at the site? You know, I'm reminded of the movie, we're just past the Christmas season, I'm reminded of the movie It's a Wonderful Life, and if you've seen that movie, great, you'll know what I'm talking about. If you haven't, I'll explain it as best I can, as briefly as I can. The main character is a fella by the name of George. George is running a small building and loan operation, and the president of the local bank, who owns just about everything, Mr. Potter, who's this mean, nasty guy, offers George Bailey is his name, a job. And when George comes in to meet with Mr. Potter, he sits down in front of Mr. Potter's desk, and literally he's sunk down like this. I mean, he just sunk way, way down. And the point is that Mr. Potter likes to try to make people feel small so that he can take advantage of them. Again, that's the kind of thing, you either let it bother you or you don't. Don't. That'd be my advice. Timing of negotiations. Be patient. Some people will try to abuse you by timing things in ways that are difficult. They'll call you at 4:55 every single time they call you. They'll send you emails that, they'll send you an email at 5:30 a.m. so that you can't possibly miss it when you get into the office. And so you get in the office, pull up your email. Let's say you get there at 8 o'clock, and there it is. And you're like, oh, my goodness, what kind of person does this? Well, that guy may have gotten up at 5:30, sent you the email that he had prepared yesterday, then went back to sleep, for all you know. Again, you can either let those things affect you or not. These are tactics people can use. You can try them on other people, too, if you choose. My advice is if they're used on you, do not let them frustrate you. They are what they are. Recognize them and move on. Credentials. Sometimes people will try to credential you to death. It was just, and by this it could mean almost anything. I have an AB, BA, BS, PhD, MD, MDiv, MED, blah, 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 the old alphabet soup thing. I'm a this, that, and the other, blah, 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 and they might try to credential you to death in that way. Okay, that's fine, but that doesn't change anything about the circumstances of the negotiation. Some attorneys, particularly older attorneys, they'll try to talk about judges like they know every judge, and maybe they do, maybe they don't. Yeah, Judge Schmo and I were out golfing last week. Well, guess what? They were at a golf tournament and happened to be at the same golf course at the same time, and met, saw each other and said hello and shook hands. Or maybe they were golfing together at the same place at the same time. Maybe they were in the same foursome. Or maybe they're golfing buddies and they golf with each other, 10 times every summer. So what? Again, it's the kind of thing you either let it bother you or you don't. You can try to use these tactics, but if you're dealing with anyone who's got any sense whatsoever, they're going to ignore this kind of stuff and try to brush it off as much as possible. The number of negotiators, does that matter? I will say this, it is a difficulty if they have 3 people and it's just you, especially if you're meeting at a place, not for the intimidation factor so much, although they could be intimidating, mostly because then you don't have anyone to bounce ideas off of, and they do, and that could be an actual advantage. So that's something you'll have to deal, if you ever have to deal with it on the fly. I would just calm yourself by knowing that, guess what, somebody's always a phone call away or an email away or a text message away. You still have some resource. Now, if I'd have been teaching this class 10 years ago, I probably would have said that's a problem that you're just simply going to have to sort of stiff upper lip and get through it. What are things that prevent cooperation in the initial orientation phase? Well, greed, because cooperation appears weak. People don't like it. People are greedy, generally speaking. I mean, look, from a standpoint of a guy who I haven't told you this, I don't think, but I'm a student at Southern Baptist Theological Seminary. I'm a Master of Divinity student. I'm a Christian man. This is a fallen world, and guess what? People are mean and ugly and nasty oftentimes about things, and that will stop when there ought to be cooperation. That could inhibit it. What else? Fear of exploitation if you cooperate. People won't cooperate often, not because they don't think it's the right thing or the best way to resolve something, but because they're afraid that the other side will take advantage. Sometimes there are professional expectations in the community of negotiators. It's just anticipated that you'll be a hard-nosed jerk. And so everybody knows that everybody else is going to be a hard-nosed jerk, so everybody is hard-nosed jerks when everybody could just be cooperative and just get it over with. Client expectations. I've talked about this before a bit. I'll say this again. Sometimes client expectations are outlandish, and you are there in part to fix that suggestion or that idea or that notion or that perception. Negotiation generated emotions. Be careful not to be the one who's getting emotional, and also if the other side gets too emotional that you just ride that wave. It's best probably if there's some anger. Sometimes people get angry, and it happens. It's okay. If you're the one who gets angry, then it's probably a good idea to find a way to diffuse the situation. If the other person gets angry, it's a good idea to find a way to diffuse the situation. Do the best you can. Again, these things are going to happen. People are people. People mess up. And sometimes it causes problems. So the best thing is to know that these things can occur. Be ready to deal with them. Sometimes it's okay to get angry. I mean, I've certainly been in negotiations where the other side I thought was being ridiculous, and I just told them, like, look, you brought me here. You're the one who said you wanted to negotiate, and now you're doing this. Why are you wasting my time? Are we going to do some serious negotiating, or is this where we're going? Because I don't want to waste my time. I got other things I could be doing. I could be other places I'd rather be. I could be with other people that I want to be with. And it may be okay to kind of let them know, hey, look, don't jerk me around. So I mean, that sort of justifiable anger may be useful sometimes. Personality conflicts, I would just say move on. If you have a conflict with the other negotiator, you don't like them, they don't like you, oh well. Be professional about it, rise above it, move on. Okay, what are some things that might facilitate cooperation? And I promise you I'm almost done. Really, literally. One, you can initiate the trusting behavior. That is, you can be the one to say, okay, look, I'm going to take a chance here, and we're going to do this in order to come to a resolution of this thing. Or I'm going to take a chance here, just tell you that here's a fact that you need to know. I'm going to disclose something to you that I'm not under obligation to disclose, but here it is. Now you reciprocate. It's risky, and it could be risky, but maybe there's a time for it. And again, that's one of those things that as you're starting the negotiation, you want to be careful about. But there may be those circumstances where you decide that it's best to sort of do that right at the beginning. You can talk about the benefits of cooperation. I strongly urge you, if you are young, that you do not go to some crusty old guy like me and start telling me about how beneficial it is to cooperate, because you learned this from Gifford, who is some authority on negotiations. No, just don't do that. Okay, you have to be much more subtle, frankly, and sort of make little plugs as you go. Little plug here, little plug there, little plug over here. Hey, this. What do you think about this? How do you feel about doing this thing? You can get to draw them. You get draw them in a little bit. Okay, you can't just hammer somebody. Active listening. This is probably one of the best things you can do in order to facilitate cooperation, if that's what you're looking for. And by active listening, it's very simple. You listen to what the person says very carefully, and then you say it back to them. Did you say that you want 2,500 square feet, but you're willing to go to 2,800 square feet? And you put it in the form of a question that forces them to respond back to you. You get a chance to, and then it gives them an indicator that you're actually paying attention, that you care what they're talking about. Whether you do or not is irrelevant. It could be on the most trivial things, quite frankly. But if it initiates some cooperation where there is none, or where you want to facilitate it right from in the initial phases of the negotiation, that's always a way to do so. Now, if you're negotiating by email, obviously that's not quite as easy, and so that'll be something that would be a little bit difficult for the purposes of their class to do that. You can talk about the risk return for certain behaviors. Basically, that means that if somebody says they're going to do X, you threaten them with Y. Or you can reverse that and say, if you do X, then I will do Y. Sort of make it more positive. Last thing, there may be some emotion, and I've kind of touched on this quickly, but I'm going to end with this. You may have emotion generated during the negotiation. How you respond to that is as important as whether it happens. And my best advice would be that you just let it roll. If somebody wants to get angry and go on a tirade, let them. And probably the best response to that is to just simply say, gosh, I didn't realize this was so important to you, or gosh, I'm sorry, did I say, take some, whether you deserve blame or not, just take a little bit of blame. Now the other side may, again, how they react to it, it's not your problem. You may say, well, gosh, they might think I'm weak. Well, so what? Just say, what? Just be the bigger person. I mean, I know it sounds trite and cliche, but be the grown-up. Maybe that's the best way to put it. Be the grown-up. And especially if their anger or their emotional outburst is really, really not appropriate. Just be the grown up. All right, that's chapter 3 and 4. Next time we'll get to 5 and 6. Thanks.